So in this case, we're going to be looking at equity as in and of itself as a source of law, the origin of equity, and then look at the equitable maxims and cases, right, that can be applied to some of the equitable maxims, right? And we're going to be looking at the remedies of equity as well, right? So some of the cases I haven't found a proper case that would make sense. So some of the maxims I don't have cases for them, right? And some of the remedies I don't have cases for them as well because it's generally just not in scope of the syllabus, so I just don't bother, right? So let's have a look at this. So equity really stems itself from the writ system. So we know that in medieval England, as we spoke about in common law, right, we had this entire writ system, right, which operated under which were basically formal written orders by the king or his officials, which allowed you to actually participate in respective legal proceedings, right? So looking at that, so limitation of the writ system now, right? The writ system had strict formalities and limitations as it only allowed legal actions that fell within the scope of available writs. So the rigidity often led to injustices as there were many situations for which a writ existed or where the remedy provided by the writ was inadequate. Majority of the time, damages was the only type of reprise that was given through the writ system. So to address these limitations, the court delegated certain cases to the chancellor, who presided over the court of chancery. So the chancellor had authority to grant relief in cases where the common law courts could not provide an adequate remedy, right? So we're looking at those type of things. So the court of chancery now, right? So it could consider what we could look at here now, right? The Court of Chancery was known as the Court of Equity and was established as a separate court from the common law courts, right? So it operated alongside the common law courts, right, and developed its own body of legal principles and procedures, right? So equity operated on principles of fairness, conscience, and good faith rather than in strict adherence to legal rules. So the Chancellor had, as the head of the Court of Chancery, had discretion to grant remedies such as injunctions, specific performance, and equitable damages. So we're looking at the advent of different remedies opposed from just damages, right? Regular damages. Damages speaks to money, by the way. All right. So the types of remedies now. So the equitable remedies were designed to provide relief that common law remedies couldn't, right? So in common law remedies were inadequate, equitable remedies were used. So for example, injunctions could be used to prevent or harm or enforce specific actions, while specific performance compelled parties to fulfill their contractual obligations, stuff like that, right? But the Court of Chancery offered greater flexibility and discretion, right, in its decision making compared to just the common law, right? So the evolution and influence, basically, what we're looking at here now. Over time, equity developed its own body of legal principles, as we stated before, that were administered by the Court of Chancery, right? And we speak about the fact that these principles were based on the fairness, equity, conscience that we talked about already, right? It operated as a separate system, right? But it also interacted with or influenced common law itself. So the Chancellor's decisions and equitable principles became a part of the broader legal landscape in England, shaping this development of English law. So the principles of equity continue to influence legal systems around the world, including those in Commonwealth countries such as the Caribbean nations. Many legal systems have merged common law and equity principles, ensuring a more comprehensive and flexible approach to justice. So we're looking at that here. So the maxims of equity, right? So the term maxim of equity refers to fundamental principles or guiding rules that underpin the equitable jurisdiction of courts. These maxims serve as a fundamental concepts that shape the application of equity in legal proceedings, right? So we're looking at these overarching values and ideas that govern equitable decision making within legal administration, right? So let's look at some of these maxims, right? Equity follows the law, right? This is a simple one here. So while equity operates alongside common law, it does not override or contradict established legal principles. Instead, equity seeks to soften or supplement or complement the law, rather, filling in gaps and providing remedies where law is insufficient. Right? So we have the first one there, equity follows the law. Alright? Equity does not suffer a wrong without a remedy. What does it speak about? This maxim underscores the principle of equity that seeks to provide redress for injustices and grievances. Right? So it means that where there is legal wrong or injury that falls within the jurisdiction of equity, the court will endeavor to provide a suitable remedy to address the harm suffered. Right? So it does not take the suffering and induces any type of sentence that is there without a remedy. It does not suffer a remedy. It does not suffer a wrong without a remedy. It always strives to ensure that no individual is left without recourse in the face of legal wrong or injustice. It tries to always fix the wrongs. So there's no wrong without a remedy under equity. Right? He who comes to equity must come with clean hands. Right? This maxim emphasizes the principle of good faith and fair dealing. Parties seeking equitable relief must themselves have acted honestly with integrity. Equity will not assist those who have engaged in wrongful conduct or misconduct. An integral case here would be Hubbard v. Vosper, 1972. And could anybody tell me the facts of this case? What was happening in this case? It was about a cult leader. Anyone? So a cult leader sought the equitable remedy of an injunction, right? To restrain the breach of copyright in a book, crucial to his cult of Scientology. Don't know if you guys remember that case, right? So since the claimant, right, was protecting his secrets by deplorable means, and he was not therefore deserving of the remedy of inequity, right? So we're looking at the means, right? So you're trying to get the copyright. We're trying to get a general company, right, to restrain the breach of any type of copyright for his book on cult of Scientology, right? But it's a cult of Scientology. So we're looking at the fact that he who comes to equity must come with clean hands, right? He was trying to protect his secrets using deplorable means. So you cannot look for a remedy in equity without doing equity yourself, right? He who seeks equity must do equity. So this is another thing that really comes after that one, right? So he who seeks equity must do equity. This maxim really looks at the reciprocity, right, of fairness and equitable proceedings. So if you want to seek an equitable remedy, you yourself must do some amount of equity, right? In order to obtain benefits of equity, one must be prepared to fulfill their own equitable obligations, right? Chappelle versus News Time. Well, sorry, not News Times. Times Newspapers Limited, 1975. Right? What happened in that case? Chappelle versus Times Newspaper Limited, 1975. Anyone can give me the facts for that case? Remember the newspaper employees who have been they were threatened, right? So some newspaper employees, right, were threatened after they started to strike, right? So they were striking specifically, right, and they were threatened that they would be sacked, so they would all be fired if they didn't stop striking, right? So an injunction was applied for to prevent the employers from carrying out the threats. But in order to be awarded the remedy, the strikers should undertake, right, that they would withdraw from their strike if the injunction was granted, right? Since they refused to do this, injunction was refused, right? So basically, they're striking. They're trying to apply for an injunction to stop their employers from firing them, right? But one of the obligations was that you would have to actually stop the issues, no, stop the striking. They said no, therefore the injunction wasn't granted. He who seeks equity must do equity, right? Equity acts in personam rather than in rem, right? We're looking at this now, right? The maxim distinguishes between actions brought against specific individuals in personam and actions brought against property or rights generally, which is in rem, right? So equity primarily concerns itself with the rights and obligations of the individual more so than the property itself. This allows a court to tailor remedies to the circumstances of parties involved rather than applying blank rules to property of rights, right? So look at that. Beswick v. Beswick, 1986, right? What occurred in this case? Remember, there was a window of coal merchant succeeded in obtaining an order of specific a widow, right, of a coal merchant succeeded in, I think, obtaining a order of specific performance, I believe, right? So what happened here, right? Her claim was as a as would be an administratrix, right? Not administrator, but administratrix, was well, of her deceased husband, right, against the assignee of his business, who had promised her husband that he would pay her a weekly sum if her husband should die. So what's happening here now, right? She was promised a weekly sum, right, if her husband were to die, right? Her husband died here, right? And she was not paid. So we're looking at that. We're looking at the beneficiaries, right? So with equity acts in personam rather than in rem, right? We're looking at the right of a beneficiary under the will, under a will, right? Specifically, right? So if we're looking at wills and stuff like that, that's where equity comes from, right? That this equitable maxim comes from, rather, right? So the right of a beneficiary under a will is a personal right rather than a right of property itself, and the beneficial right to land cannot therefore be assigned or sold at common law, right? So we're looking at stuff like that. So equity looked at to the conduct of the person and intervened to permit such contracts to be enforced. So we're generally looking at that. Equity looks to intent rather than inform, right? So equity focuses on the substance of an underlying purpose of transactions and agreements rather than merely for their formalities. So it considers the true intentions of the parties involved and seeks to prevent injustice resulting in technicalities or formalities. Right? What we're looking at here for equity looks in the intent rather than in form, right? You could be looking at the case, right, of, well, the statute of frauds. That is actually not the case, but a statute itself, primary legislation. Or you can look at Singer Sewing Machine Corporation versus the Montego Bay Corporate Credit Union Limited in 1997. Right? So that's a good case to look at for that. Alright? So for the equitable remedies now, the remedies that come under equity are few. I just put a few in here. Right, so specific performance is one that we normally see. So it's an equitable remedy that requires a party to fulfill their contractual obligations, right, as is specified in the agreement. So it is typically available in cases involving unique goods and or services where monetary compensation would not be adequate, right? So looking at that. We also have injunctions. Injunctions are court orders that require a party to either refrain from doing something or to take specific action to do something. So you have a prohibitory injunction or prohibition, and you have a mandatory injunction, or it is stored under mandamus, right? So they are commonly used to prevent irreparable harm, enforce contractual obligations, or protect legal rights. So looking at the Demerara Turf Club versus Fang in 1968, American Cyanamid versus Ethicon 1975, which is a locus classicus, right? And we also have Colossal Quarry Limited versus Teamwork Trinidad Limited, right? Which is a part of ex parte injunction, right? So these are some of the cases that we can find under injunctions. Alright? Injunctions are orders to tell persons, to stop doing something or to order them to do something through prohibition or mandamus. Alright? We also have rectification, right? A remedy used to correct errors in legal documents or contracts that are not accurately that do not accurately reflect the parties' intentions, right? So Craddock Brothers versus Hunt would have been a good case, and Templist Properties Limited versus Hyams, right? 1999. So those are good cases for rectification there. So hopefully we would at least know one case per thing. That is one thing that my law teacher driven into me, that every single legal principle, every single topic, I must know at least 5 cases, right? In the case that we do have 5 cases, at least one is good enough. You need to know at least one case for everything. Alright? Right? So there's a difference between just, regular law student passing with a 3-4 or whatever, or getting a meritless placement, right? Because I wanted that meritless placement. So I got it. Right? So we went through these things, right? We know our cases, and that's how my entire friend group got on the merit list, right? So all in the same order, one behind the other on the merit list, right? So these things are set apart the difference between a regular Cape Law student and somebody who wants that distinction, that straight A profile, right? So know the cases for the specific things, be able to refer to them. You also have rescission, right? So it's a remedy that allows a contract to be concealed or set aside due to factors such as misrepresentation, mistake, or undue influence, right? So that's another one there. We also have constructive trusts, right? Equitable remedies that arise when a person holds property under circumstances that make it unjust for them to retain the beneficial interest in the property. The court imposes a trust to prevent unjust enrichment and ensure fairness between the parties, right? And the last one, we have an equitable estoppel. So an equitable estoppel prevents a party from asserting a legal right or defense that is inconsistent with their prior conduct or representation rather. Right? It is invoked to prevent unfairness or injustice where one party has relied on their on their detriments or to their detriment, right? On the other party's words or actions. So Hughes versus the Metropolitan Railway, 1877, and that is the last case there under the equitable remedies. That brings equity to a close. All right. So that is there. So the equitable remedies, equitable estoppel, constructive trust, rescission, rectification, injunctions, and specific performance. The general maxims I looked at is equity looks in intent rather than in form. Equity acts in personam rather than in rem. He who seeks equity must do equity. He who comes to equity must come with clean hands. Equity does not suffer wrong without a remedy, and equity follows the law. Alright? We'll look at the evolution of equity from the course of chancery and the writ system. And that is equity as a source of law.